Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. I want to clarify you an important update concerning bail, which is recently given to us by Honorable MP High Court. Judgment is dated 18th of Feb 2026 in that case. An appeal was submitted before Honorable High Court as per the protocol of Section 14A of SC/ST Act. As we know that whenever the bail is submitted to the concerned special court, SC/ST, and it has been dismissed, the remedy lie before Honorable High Court by the virtue of appeal. For this, we have to rely on Section 14A of the SC/ST Act. So, in that case, the bail plea was submitted before the concerned trial court as per Section 483 of BNSS. Finally, the bail plea has been dismissed. The offence is concerned with cheating, and apart from that, Section 3, Subclause 2, Subclause 5 of SC/ST Act is also added. So, basically, whenever you are going to submit the bail plea, you have to show that why you are falsely implicated. So basically we have to find the answer to the query why. So if you are going to make the submission in the general way, our submissions are general, unspecific, we could not be succeeded. In multiple videos I have submitted to you, just read the FIR, and in case charge sheet is submitted, read the charge sheet. We have to find out what is our exit role. If our role is general, unspecific, and there is no specific evidence against us, and the evidence so available are inconsistent, and there is lack of corroboration, we could have a very good case to be succeeded for the bail. So do not be in the anxiety or panic while moving for the bail plea. Just read the entire FIR. Find out your specific role. And apart from that, we have to see whether the facts on the ground are going to suggest an inference regarding the commission of the offense. If the allegations are not going to suggest the positive inference, then we could have the benefit. So we know that the burden is on the prosecution. And apart from that, the liberty of the concerned accused could not be compromised in the routine way. The police has to specify why the arrest is sine qua non. Because Honorable Supreme Court in Caton of Judgment specified that the power of arrest is one thing, but the exercise must be lawful. And apart from that, Section 35, Subclause 1, Subclause B of BNSS specify that while doing the arrest, the concerned police is required to specify the reason. So the arrest could be done if the cognizable offence is done in the presence of official. And apart from that, the accused is going to do obstruction in the course of investigation. So for doing the proper investigation, the arrest is must. It could be done. And apart from that, the possibility is that the accused is highly influential person. He may threat or disappear the evidences or cause disappearance of them. In that scenario, the arrest could be done. And apart from that, there's a possibility of the accused to flee away from course of justice. He could be arrested. But in the routine way, he could not be arrested. So basically, we have to show that there's a due compliance of Section 480 Subclause 3 of BNSS. So in that way, we could have a dominant case on the record. And apart from that, we have to give the plausible explanation of the allegations on record. If our explanation is plausible and we are going to create a suspect or a suspicion in the case of prosecution, we could have a very good case on record. For example, if the dispute pertains to a civil dispute and ultimately it has been converted into a criminal prosecution. So we know that in a case of civil dispute, criminal prosecution would not lie. So if even the member of SC/ST inter alia indulges in a criminal case and the submission appears to be a civil dispute, in that scenario we could have the benefit. And apart from that, if charge sheet is filed, we could have the benefit. And sometimes the court may say or could direct to move the bail plea after examination of the material witness. If material witness are not examined within a specific time, if examined, they are not going to corroborate the story of prosecution, we could have the benefit of bail, as observed in this case also. And apart from that, whether the accused is having the criminal antecedent or not, if he is not having, we could have the benefit. So in nutshell, we could say that the compliances of Section 480 Subclause 3 of BNSS is must. And apart from that, Section 35 Subclause 1 Subclause B of BNSS is quite important. And in addition to this, the facts are quite important. If facts are not going to show any infringement of the legal position, we could have the benefit. So I specify you the step in which manner you could proceed and could avail the remedy of bail from the consent court. See you in the next video. Till then, Jai Bharat, Jai Mahadev.